behalf of Legal Innovation to the panel discussion on mediation advocacy. Before we begin, I would like to quickly remind all the participants to remain muted. And if you have any questions, we encourage you to type it in the chat box. We'll make sure to attend all the questions towards the end or during the Q&A session. So without further ado, I would like to introduce all the panelists for today. However, one of the panelists, Dr. Deepika Saini, unfortunately will not be able to join us today due to some personal reasons. So first we have Ms. Rukmani Menon. She's a director at Camp Arbitration and Mediation Practice. She began her legal profession at Khaitan & Co., New Delhi, worked in a legal department of an F- FMCG company in Bangalore for 8 years. She started independent legal practice 25 years ago and handled matters pertaining to indirect tax and commercial matters. Ms. Menon has been a mediator since 2015. She is trained with GEMS USA and Bangalore Mediation Center. She is a mediator at Bangalore Mediation Center and has mediated over 500 cases. She was recently appointed to the global panel of mediators for the workplace mediation by the UNDP. So we welcome you, ma'am. Next, we have Miss Kriti Johri. She is an academician at GGSIP University and AVP at Accords International, pursuing doctoral studies at NLU Jodhpur in corporate law. She is trained mediator, spreading mediation and negotiation training at Accords International. As a Wipro, ADA young member and experienced legal researcher, blending academia with practical expertise. We welcome you, ma'am. Thank you for joining us. The panel discussion will be moderated by Anubhab Banerjee. He's a mediator and an advocate. He's currently working as a principal associate at CAMP. Over to you, sir.
Thank you for that introduction, Kriti, and a warm welcome to everyone present here. So, as we are going to talk on mediation advocacy today, I thought before we begin the discussion, I set some context onto what is mediation and what are the things we would be looking into for this session today. So, just to simply put in words, mediation is a third-party facilitated negotiation. This is a process that requires a unique skill set from all the stakeholders that come in for this process, be it the mediator, be it the advocates, or be it preparing the parties who are coming in for the process. Now, our court systems in India offer us three modes of resolution for disputes. One is a traditional mode of litigation, wherein we go in for a rights-based approach where we go to a court to seek justice or to seek out a resolution based on our rights and based on the laws of the country. The next process is arbitration, which is similar to a litigation, but in a private setting, where we get to choose our own arbitrators who then get to decide for us depending upon our claims for our rights in a particular case. And the third is mediation, wherein the third party here does not give a decision, but the third party here acts in as a facilitator for facilitating a discussion between the two parties who are at dispute. And this process and the mediator requires a particular skill set that enhances them and helps them to enhance communication with parties in a dispute. Now that we have an understanding of the difference between all of these processes, we've got the Mediation Act 2023, which is a forward-looking litigation, which is a forward-looking legislation in the country, with which we are hopeful that mediation gets its place into the business communities, into the legal communities to help resolution of issues and resolution of disputes in a more amicable way and in a better manner for business that also saves relationship. And with that, and without any further ado, I would like to shift on to the topic of mediation advocacy. And I would like to invite Ms. Rukmani Menon to answer a few questions for us. Being a mediator and being a mediation advocate at scenarios, I feel we would be obliged to get in her experience or two things. Which brings me to my first question, which is what we are taught at law schools or what we see happening around us at most times is trial advocacy. That is when we go in, when we try out our advocacy skills at the courts. But something that's different in here in mediation and what we are going to talk about is mediation advocacy. And ma'am, that brings me to my question as to what do you feel are the differences? What do you feel are the different skills that might be required between when we compare both trial advocacy and mediation advocacy?
Uh, Thank you, Anubhav, and thank you, Kushi, for the introduction. Thank you to the participants for being here. That's that's a very important difference, Anubhav. Uh, as Anubhav is saying, and I think most of the participants here are legal professionals and students. So, what we learn in law school is about how to be a good counsel representing your client either before court or in arbitration. And what do you do for your client when you're in court, or what is your aim or goal as a lawyer when you go do that? Your main aim. Am I audible?
Yes, you are.
Yes,
Yes,
ma'am.
ma'am.
Anubhav, am I audible?
Yes, you are. Are we
Okay.
audible to you?
Yes, ma'am.
So, our main aim in when we appear as a litigation lawyer is to ensure that we win the case for our client. At we want to ensure victory, and we want to make sure that the other person sort of loses, because if you have to win, the other person has to lose. And so, it is a win-lose situation, and we prepare that way. We get all the facts from our clients to ensure that we can build up a good case for our client. We can then rely upon previous decisions, argue in court, and persuade, or rather argue in favor of our client to ensure that the person we are representing wins the litigation, or for that matter in arbitration. There's a very thin line between arbitration and litigation. I mean, I always say that arbitration is nothing but litigation in private. The difference being you can't choose a judge, but you can choose the arbitrator. Now, what is the difference in the basic difference? Being in mediation, it is never the mediator who decides on behalf of the parties as to how a dispute is going to get settled. It is the parties. It's a self-determination process. It is the parties who have to decide how uh, how the parties want the whole thing to be settled, how they wanted to collaboratively work on it, how they can come out with a solution to resolve the dispute between them. It's a win-win situation. It is never. And now, who is there over here to guide the client? In our country, in India, as Anubhav told you, the Mediation Act has just recently come in. Having said that, I would also say that mediation in our country has, been there for centuries. I would say in Mahabharata, Lord Krishna tried to mediate. It did not work. You have since, I mean, for the last hundreds of years, look, panchayats in village, where they try to resolve issues. Of course, it is the panchas, or the seniors of the village who try to solve the issues, but they solve it. In mediation, is never the mediator who resolves anything. It is the parties who resolve it. So now, as a counsel, If I, in a litigation or arbitration, it is my main aim to win for my party. As a counsel in mediation for my client, I have to wear a different hat. I have to sort of coach my client. First of all, I have to understand the difference between the two. Here, I'm not in mediation, I'm not arguing for my client before the mediator. I'm helping my client in negotiating, negotiating a settlement which will not only be beneficial for my client but for the other side also, so that there is a final closure to the dispute. So I have to understand what, as a counsel, I have to understand the finer nuances of mediation. Only then, as a counsel, will I be able to sit, because it's a being a party centric process. It is the party who does most of the speaking in a mediation, unlike in a court of law, where as a counsel I speak, or in arbitration, the counsel speaks. So I have to make the client understand. When a client comes to me, as saying that I have so and so dispute, what is my first duty? I have to see that which process is most suitable for this particular dispute. Normally what happens is, what our legal what do you call it, learning in colleges and all, off late it's slightly different, but I'm saying maybe last 10 years is different. Otherwise, what do law schools and all teach us? That the only solutions available are arbitration and mediation, arbitration and litigation. So I instantly, whenever a client comes, your first thought is, okay, let me file a case for my client, or if there's an arbitration clause, let me start the arbitration process before an arbitrator. So with the advent of mediation in our country, with more and more people, lawyers and clients and corporates, becoming aware of the process of mediation, what happens is, you have to make the client aware that yes, there is another process. There is mediation. Maybe your case is more suitable for mediation, because it'll take lesser advantages, disadvantages of the various processes. Let the client take a very informed decision. Help him or her take that decision as to which would be the best suited. Similarly, you should tell your client in advance that I'm not arguing for you. This is negotiation. I'm helping you negotiate so that you can, be more collaborative. You can come out with more options. You can understand your own underlying interest, the underlying interests of the other side, and then you can take an decision. So this is the main difference between a counsel in mediation and a counsel in a litigative or an arbitration process. Anubhav, can we move to the next question, please?
Ma'am, if I'm hearing you right, then mediation advocacy is something that might also require a particular skill set.
Hello?
Am I audible?
Yeah.
Yeah. All right.
Yeah.
So as we heard from you, that mediation advocacy requires a different skill set as well, I assume, from what trial advocacy does. You also did mention about negotiation being an aspect, and negotiation being something that we need to be careful about when we are advocating it for our clients. That moves me to my next question to check in with you, that what do you feel are the important skills an advocate should possess when they are going in as a mediation advocate and not as a trial advocate?
Yeah. So, in reply to your question, I would say that since these are, very different kind of processes, you need to, first of all, to begin with, as I said in the previous, in my reply to the previous question, you should be clear. I mean, all the students today have ADR as a subject, so you're aware of what exactly is mediation. So you have to be aware of the process of mediation, how it works. And the skill sets is that, you understand negotiation. To be able to explain something to a client, you should be good at it. So negotiation is the most important part of mediation, because we define mediation to be an assisted process of assisted negotiation. So you should, I mean, as a counsel, you should know, you should have the skills of being able to identify underlying interests of your clients. You should be able to coach your client to, to be able to negotiate. You should be able to tell your client that this process is a collaborative process where both the sides have to move together, that you're no longer fighting against each other, but you are trying to collaborate with each other so that you can find a amicable solution to your problem. You can only when I mediate, I always tell the parties and the councils that the success of this process largely depends on your mindset. If you've come in with a very a same sort of mindset with which you go to court, there is very little chances of the mediation being a success. As a mediator, we assist over there, but the councils and the parties should be in that collaborative frame of mind. And who's responsible for that? The council. So the council should understand, let me reiterate it, should understand mediation, should understand negotiation, should be able to coach his client as to what exactly the process is about. What he should be able to, tell his or her client that what are the different cases which are amenable to mediation. Right, I mean, before advising to go in for mediation. These are some of the basic skills that a mediation counsel should possess. I suppose I'm clear about that.
So, ma'am, as I understand that a mediation counsel needs to possess certain special skills when they are going in for the sessions to help the parties collaborate and come down to a win-win scenario and not just think about a compromise as well in those scenarios. Um, and you also talked about your experience as a mediator, and that's what I want to explore a bit more as to with your experience as a mediator, how do you see a good mediation counsel or a good mediation advocate affecting the process? Means just to put it to you again, if you're sitting in a mediation wherein you have couple of or even one good mediation counsel with you, does that help you in the process? And if that does, how does it?
Anubhav, I missed the last part of the question.
So I'll just put it to you again. When you're sitting in as a mediator, and if you have a good mediation counsel with you, a good mediation advocate with you on the table, does that help you in the process or not? And if that does help you, then why or how?
Yeah, good question again, Anubhav. Yes, of course it does. As I said in reply to my last question, the success of a mediation largely depends on the parties and their counsels. Now, the parties are coached by their respective counsels as to what to expect from the process. So, until and unless you have counsels who understand the process well, understand their role in the process well, it will be difficult as a mediator. One finds it very difficult to what do you call proceed with the process, because if the counsel, you take a counsel who's hell bent on uh, telling the client that I don't think mediation, there's much in mediation for you. I think in court, if I argue and your case very successfully, I'll be able to get you a better deal. Mediation, you will have to you'll have to settle for something far lesser. So if you have a counsel who does not understand mediation, maybe who does not want his client to mediate because of professional reasons, those being that somehow lawyers feel, and maybe to some extent feel that if the case gets over fast, they lose their fees, right? So I've seen lawyers who do this, who tell their clients that don't bother, let's go back to court. And then there is no, for a client, see, we cannot put down a counsel before the clients. They have to get the due respect. And outside also, anywhere, if the client solely relies upon their counsel to give them advice and they think they're getting the best advice, but that's not always so. So for till a counsel is fully invested in the process of mediation, it's difficult for the mediation to proceed successfully. It is the mediator. See, we all are lawyers who are what do you call it? Also mediators. We totally switch hats when we sit as mediators. Now, if you have you don't have a very, what do you call it, supportive counsel. And though you may know the law, see, as mediators, we always tell the parties that we are not here to advise you as to what to do or what not to do. For seeking legal advice, you have your counsels over here. So we expect the lawyers to be prepared fully for helping their clients negotiate, then also be very up to date about the legal aspect of their respective claims. Now, if you have lawyers in mediations who come in who are not very sure, mediation, though, is a very flexible process, it's always done under the umbrella of the law. So you have to make sure the lawyer should know, the counsel should know, what the legal position is. We may not, unlike in court or arbitration, you may not quote decisions because you're not here to win, but you should know how, when you do a reality test, you should know what is the actual legal position vis-a-vis a particular aspect. So till a counsel is very well versed with all this, it is very difficult for expecting a client to be able to do a successful mediation. So, personally speaking, and this is a general view of most mediators, they rely quite a lot on the counsels for their parties to the dispute to make it a process which moves along, which helps the parties.
So what I'm
So I
gathering from you is a mediation advocate is somebody who needs to be a strong support to the parties when we are sitting in to negotiate out a business dispute. And
Yeah.
it must be with or without a mediator. If we have a good mediation advocate can possibly help their clients negotiate out better deals, not spend a lot of time at courts, and also maybe retain these clients for a longer time period with themselves because they'll be providing fast and amicable services to them. Is my understanding right in there?
It is. And one thing I always do tell lawyers, we do workshops with lawyers where we tell them that, or individual lawyers, that this is not loss of revenue for you. If you have 10 cases, it is not necessary that you mediate or you advise your client to mediate in all the 10 cases. You look at it very logically and see what is best suited for mediation. There are lots of matters which cannot be mediated. For example, interpretation, tax, policy matters, certain non-compoundable criminal offenses cannot be mediated. Similarly, there are some cases which are more suitable for arbitration. So it is everything depends to a large extent on a counsel. And this loss of revenue this fear should not be there. And you're not doing, and no counsel is doing, representing his or her client in mediation free of cost. It may get over fast, you know. It may get over fast. I remember a statement made by Mr. Sriram Panchu, who's one of the leading, not only a leading mediator of our country, he's a senior advocate, and he's a very respected arbitrator. He's told us during during a session that he always, whenever as a mediator, when he sits and they resolve, he always tells his parties that, you know what, it's because of your counsels you've been able to reach a settlement. You be sure to ensure that they awarded well and they paid very well. Just because this has got over in a month's time doesn't mean that, you sort of do not pay them, do not pay them well enough for their services, because it requires a lot of extra effort to do the whole thing within a month. So yes, that is my answer to your question, Anubhav.
Thank you for that, ma'am. And I guess we now have set a context onto mediation advocacy being a different skill set altogether and a different space altogether for advocates and for young professionals to explore. And that brings me with a few questions to Kriti to come in with her academic standpoint on things as well. Wherein I was a law student a few years back, wherein I did not see a lot of activities happening around area, especially maybe in the university I was in. But yeah, there were things happening around the world. Right now, we are at a place where we are seeing so many different events, so many different mediation competitions, so many trainings that are taking place. But yes, for to get me invested onto mediation, it took just one workshop, but I could see so many people who never at all got invested onto the subject after the workshop or after so many other things that they might have participated in. And that brings us to a place where maybe we need to explore that what are the different things that we can do in this space to improve ourselves and to see how can we be more connected to the industry. And Kriti, that brings me to the first question for you as to how do you feel as young professionals and as law students we can nurture our skills for mediation advocacy?
Thank you. Thank you, Legal Innovation. Thank you, Akshay. And thank you, Anubhav, for the question. So you are right that there are a lot of, unlike the situation a couple of years back, we see a lot of ADR competitions these days in law schools taking up. I must compliment that the bridge between the industry and the academia has bridged a lot because of these competitions where we have actually hands-on trained mediators who assess students, and they give their valuable feedback to the students, and participants end up learning a lot from the people who are actually working in the industry. So yes, but a lot has to be done when it comes to academia, because the orientation towards ADR and mediation especially begins from the law school for students. And I think it will be best if the academics itself equips itself the best to train students for the mediation advocacy and for the mediation practice. Because initially, when students graduate, it's highly unlikely that they would be getting a chance to settle a matter as a mediator. But there are quite bright chances that they would be a counsel in a mediation process or in a mediation case, or they would be assisting their seniors in a mediation process. So I think grabbing what the skill of this mediation advocacy is, and just like Rukmani has highlighted, that how is this skill different from a skill that a advocate requires, is quite different. So I think it's important that we understand it right at the law school stage. But how is it different? So as a faculty, as a teacher, I'll say that when we teach students, we teach so many subjects to students. So our style, our approach is very adversarial in nature. And the reason is because we are in a legal system that is adversarial in nature itself. So teaching, while training students on different issues, and the case law, which is a source of law in this country, right? And all those case laws are themselves adversarial in nature. So even our pedagogy and the teaching style itself is very adversarial. So the first thing that we require for the academia to prep itself to promote this mediation wave and mediation, I'll say the movement, the movement that has been unleashed, especially after this bill. So it's important that we need to bring a change in the pedagogy, change of the teaching style that we have adopted so far. That is, we need to stop being adversarial, and we need to, because we are very creative when we explain students as to how they can argue in a case, how they can argue before a court. But at the same time, it's important that we also teach them that how at the same time in the similar case we can be collaborative. If the faculties themselves teach them and orient them that how they can be creative in generating options, and those options are nothing but just the creative solutions to a dispute. And this is a very important skill for a lawyer, that is creative problem solving. So that is again a very important change that is required for the academia to prepare itself. Secondly, and that's important, is advanced experiential learning. So when, just like Rukmani has been assessing a lot of mediation competitions at various law schools across India, what I have also witnessed as a ADR faculty is that when it comes to experiential learning in mediation, especially, the focus is more on what the role of the mediator is. But seldom we focus on what the counsel in that mediation competition or in that mock mediation setup, what is the role of the counsel there? How, what, at what time he's supposed to intervene? Because we do emphasize that mediation is about interest and the needs of the client. But when, because a lawyer, a student who's sitting as a counsel in the mediation process is coming from adversary, is coming from adversarial tutorials, I'll say, right? But how he's supposed to understand that where he's supposed to intervene, how he's not supposed to talk about the entitlements of the clients, but understanding the only the interest and the needs, and you have to interfere, you have to interject at the right moment. And at the same time, the most important thing that I feel that especially this mooting culture in the law schools that does not quite acknowledge, and that is how do we handle emotions. Because in the whole in the whole litigation process, mediation is not placed, it's not positioned well, it's not positioned prominently at any part of the process. But here in the mediation, students have to deal with emotions. So how it's important for the ADR faculties, and it's important for also because now there is this trend of industry people coming and directly interacting with the students. So it's also important that in the pedagogy and in the teaching style we also look at this aspect, and that is that how unlike the usual litigation style that we inculcate in students, we also when if we want to prepare them for mediation process, then they should also understand, they should also learn that how do we handle emotions. That's very important. And at the same time, it will also, it's a win-win for the students, because it makes you it gives you a personal growth, because you become better, because you become better at the soft skills. Time management is very important, because in litigation there is no time management. We know that our disputes go on and on for long, but here in the mediation process it's quite time bound. I'll say we cannot expect a mediation, or because it is controlled, not controlled, or let's say it is facilitated by the mediator. So yes, there is a limitation of the time. You cannot expect a mediation to continue long for years, just like a legal dispute does. So time management is again a very interesting opportunity that students learn. So yes, from the academia, from an academic point of view, I'll say experiential learning and the bridge between the industry and the academics is very much important if we want to nurture, if we want to shape advocates for mediation process as well as for the litigation process.
So Kriti, if I'm hearing you right, you've put focus on how important experiential learning is, especially in making a shift from the adversarial to collaborative, in making the shift in the mindset of councils and students on looking into disputes and looking into people sitting opposite to us as our partners rather than as our enemies sitting on the other side of the table, because we are in this dispute together to solve it together. And I guess this just put my thoughts back into this particular case that I was a part of, wherein I saw a known company receiving a legal notice wherein it received a notice for mediation, and they were worried. Okay, the first thing they did, they knew me, they called me, they're like, we've received this, what do we do? They're calling us to the court. And they were like, okay, now we don't want to begin a court process and all, just do whatever you want to do, and we don't want this around. As I went, this was when I was just appearing from the other side. As I went to check in with, there was a college student who had filed this case against a company who had sold him a laptop, and he was not happy with the services. When I went, I talked to him. We ended up getting into a deal and everything happened. The student left the table super happy that he got more than what he wanted. And the salesman with whom I went, he left the table super happy that he did not have to give in anything. But both were happy in their minds that we got the deals that we wanted to get without actually seeing that, okay, he wasn't hurt as much as I would have liked to hurt him. And I guess that's the beauty of the process that we can embrace as well. And
yes,
that also brings me to a place, Kriti, as you talked about competitions, as you talked about events happening, can we explore a bit more onto what are the kinds of opportunities that are available to learn and to practice mediation advocacy? If I had to today start out and think, okay, this is something that looks interesting to me. What are my ways out? How can I learn more about mediation advocacy? How can I practice more about the subject?
right. All right. So I think I'll cover your question in two ways. First, I'll talk about that how advantageous it is for students to learn about mediation. And second, I'll talk about the opportunities that are available for the students and what are the different ways that during their law school career they can focus on this skill. Because the significance of this has been already highlighted beautifully by Rukmani. So because in law school, I have seen this trend that students are motivated by the wave, by what is in vogue, what is happening in, let's say, the majority of the law schools. And mooting is definitely one culture that if every student would be involved into. I've seen students commenting that moot is must, internship is must, and internship in best law schools is must during your law school journey. I see a lot of blogs online where senior students are commenting they are guiding their juniors. Yes, mooting is important, but at the same time, if you participate in different competitions like mediation competitions, of course, the skill of active listening is something that you get to practice only in this kind of a competition. Because in mooting, you are just defending the skill that is, of course, analytical, logical, the basic skills of a lawyer. They are always in practice no matter what you do. They're always in practice in this profession. Even we as faculties, we practice that skill. But your argumentative skills, that is when you defend your client, that is something you practice the most, in fact, the best in a moot court competition. But when you participate in a mediation competition, active listening, your skill of summarizing, your skill of negotiation, your skill of reframing a particular question and reframing it in a style that it fits the parties, it fits the environment and what the momentum that's going on in the mediation process. How do we prepare opening statements that are tailor-made, that are best for the clients, for the mediator, and for everyone in the mediation room. All these skills are something that you learn only by participating in these mediation competitions. Secondly, creative problem solving, because when we are participating, when students take part, or when even they intern, right, when they appear before the court, this creative problem solving is something that they themselves are not doing as such. That is something, because in mooting or in litigation, it is very much guided by what the law says, by what is permitted by the legislation. But in mediation, we have this liberty, we have this freedom. Of course, just like Rukmani said, that it is under the umbrella of the law. So you cannot go beyond the four corners of the legal system or what the legislation is saying substantively on the dispute. But at the same time, the how of it, of course, what is directed by the legislation, what the parties would be getting, but how they would be getting, how they can satisfy their needs, their interests, that requires a lot of creativity. And that is something that students get to practice. That is the opportunity that the student will find only in the mediation competition, that you may not find in your moot court competitions and other competitions. Secondly, the client-centered approach is something that this mediation advocacy practices adeptly, unlike the traditional advocacy that's involved in the litigation. Because here, our objective is to empower our client to make informed decisions about the settlement of the dispute and what are the options that would be best legally for our client. This is not something that we do that is not something that we do very often in your moot courts or in your litigation process. So unlike the traditional advocacy, where a lawyer is just making strategic decisions on behalf of the clients, and they just advocate, they just defend their legal interests. Here you get to defend, not just, you don't defend, but here you get to acknowledge and you get to position, or you get to place what the other interests, or let's say what the emotional needs, what the emotional interests of the clients are, right at the table on the mediation. That's an opportunity that you don't get in your litigation style that you practice a lot in the mediation. So what are the opportunities? Now I'll talk about that. What are the opportunities? First, right at the law school level, I'll say take part in these competitions, because we have a lot of students as well here in the audience, right? So participate as much as you can in these ADR competitions. At the same time, we have, and just like legal innovation has given us a platform to discuss this topic, right? Attend these webinars, seminars, training workshops that are related to mediation. Attend these the most. Interact if you have any link, or if you know any person from the industry who is practicing regularly in this area. Learn from that person, associate, collaborate, intern, whatever that is possible, do that. And learn the skill, because 5 years invest on the skill. That's very important, because after this 5 years, what you get into is application of the skill that you have learned. And along with this application, you keep on learning. So you don't learn per se the skill after you are out of the law school, but you just keep refining your skill that you've already learned before. And that is the best journey for a law professional, I'll say. So whatever you have learned in the 5 years, learn the best. And then after 5 years, you practice. Is my internet stable, Anubhav?
Yeah, it is. It is. It's a bit glitchy, but
Okay.
it is.
Yeah, because I just got a pop-up that my internet is unstable. Yeah, so yes, so one advice that I would give to the students is learn the skill right at the in initial years. Mooting is something that I think because we Indians have that, we listen to respond. We don't listen to understand. So adversarial skill is something that is quite, we practice a lot. Because whenever someone would question us or something, we immediately get onto the task of defending ourselves. So we are quite good there. But when it comes to understanding someone, understanding and listening to them properly, giving them whole attention, that's something that we don't do quite often. So if you focus on these skills right at the initial years itself, that will benefit you a lot. And by the time you'll graduate, I'm pretty sure that you will be reformed, because I have myself experienced this. My own students at the law school have been doing this. They have been taking part in these webinars since the first year itself. And one of them happens to be Kushi, who's here today, introducing all of us. So yes, and by the time 5 years are over, so yes, you will have a lot of opportunities for yourself, for because this industry requires people who know the skill. That's very much there. So practice it in the initial years itself. And uh, we are trying, like just like camp offers internships that helps students understand the mediation process, right? So if at all there are other organizations, intern with them. That's also very important. When you, because mediation is the norm, it is the law, and it is going to continue. It's going to get more stronger in the coming years. So even if you are interning with a law firm or with a council, if you happen to have a chance to observe mediations proceedings, do avail that opportunity. That will help you a lot, because tomorrow when you may be a counsel in the mediation, you will be understanding that what exactly, how you have to handle the situation. Because learning mediation is very different from practicing mediation. And this, I think, Rukmani can very well explain that it's a very different skill when it comes to practicing it. It's very easy to learn, it's very easy to grab it, understand, it's very easy. But when you sit on, and when there are actual parties, when they're real life parties, because at law school we give you simulations. We try to give you a we are giving you a mock experience, try to give you a real life experience, but parties are very different in real life. If you make any error as a counsel or as a mediator, that's it. They'll be sitting on your head. So that's a situation that you don't want to get into. So collaborate more and more with industry people, and this is what we law schools are attempting. I only see NLS Bangalore last year. I think camp was involved in the workshop, 1 day workshop on mediation advocacy, where we also had Victor from US, talking about mediation advocacy. So far, I've only seen this initiative from the NLS Bangalore. None of the other law schools are quite active when it comes to mediation advocacy. So we are not quite training students as to how is this advocacy skill different from the usual advocacy skill that you are practicing a lot. So I hope that such kind of workshops, we'll be doing something back at our law school soon with camp, of course. So yes, that's very important. And only then you will be able to grab the skill and understand the difference. So yeah.
Thank you for that, Kriti. And I guess it's about knowing as young professionals, as students in law school, about the difference in the two mindsets of competitiveness and collaborativeness. Uh, because somewhere down the line, I feel when I took my first personality test in my law school, which was years back, I was very happy that I was a competitive person, but then being very close to the mediation industry when I took it the latest, I saw that my collaborativeness quotient has quite much increased than what it was for competitiveness in there. And uh, That also brings me, and as you said, there are certainly a lot of options available in terms of trainings, in terms of competitions that students can go down to. We at CAMP have several trainings for young professionals and students. There are other organizations like the PACT who also constantly associate and host a lot of trainings for students. And I also know, Kriti, that you are associated with Accords International, who also does a lot of trainings for students and young professionals across. My next question is, I guess, for both you and Rukmani, ma'am, and that would lead us.
Anubhav, can I just come in for a
Mhm.
moment before you go on to the next question?
Yes, sure.
This is with reference to, Kriti's just handled it so well. It is, and she being in academics knows much better. But as Kriti very nicely sort of brought it out, it is so important, to know about, not only about, see, it's a totally, there are two things. One is mediation, one is how to be an advocate in mediation. It's so it's so very important for law schools, to have some kind of either a workshop or, in their when they're teaching mediation, to teach also about how to be a good counsel in mediation. Because why I'm saying this is, when students pass out, even if they've done their 40 hours mediation course, they're a bit too young to be mediators. I think, Anubhav, you know that very well. You've just started, being maybe co-mediating. So when you participate, you cannot become a mediator immediately, but you can be, as you're a counsel in a litigation, you can be a counsel in mediation. And the more you participate as a counsel in mediations, the more you learn about the skill, and maybe 4 years down the line, you are ready to step into the shoes. You're ready to be a mediator. So this training of advocacy in mediation in the long run will help students in becoming good mediators as they, as they grow in the profession. I just wanted to add that. Thank you.
Ma'am, and I guess thanks for adding that down, because that was exactly my next question to you and Kriti, that how do we see mediation advocacy skills getting nurtured in our law schools? And how do we maybe want to see them getting nurtured in our law schools? Because there are two different aspects, as Kriti, you as well said, and Rukmini ma'am also mentioned, mediation advocacy and trial advocacy, and both are equally important. It's not that one can take an upper hand over the other, but both are equally important in their places. And as I guess we have an answer with us, as you just answered, that law schools need a lot of more of these trainings to come into the picture. We need faculty to be better informed about all of these subjects, all of these aspects about the practical skills of mediation and advocacy, because here it's not just about law, it's so much more about psychology, it's so much more about understanding people. It's so much more, as Kriti said, as well, about emotions, which really don't matter for us when we are going into a court of law. And Kriti, any thoughts that you have to add on to this as to how do you feel law schools can nurture these skills even further?
Anubhav, you just mentioned it, what I was about to share. That is the training of the faculties. Because I do interact with other faculties who teach ADR and mediation at law schools. Seldom I see them focusing on the, I say, the intensity of the mediation process, the depth of this process, that this process is not just about a mediator. This is not just about, because one word that whenever we talk about mediation, we talk about collaborative. How can you be collaborative? Is collaborative style something that you can inculcate only in one semester during by devoting just 40 hours, 50 hours of training to students? No. That is something, just because adversarial style is something that I, as a faculty, we teach right from the beginning. We train them to think from a plaintiff side, from a defendant side, from the prosecution side, and from the defense side. That is what we train them. that this would be an argument from this side and this would be an argument from the other side. But we don't do the similar thing when it comes to mediation process. So explaining the process in detail and explaining them that how is advocacy here different from the advocacy that we have been learning in other subjects. Because ADR and mediation, and frankly, mediation is only restricted to just one unit in the ADR, in the whole legal curriculum, I'd say. It's only one particular, let's say, maximum 10 lectures per curriculum. That is really that's nowhere at par with the kind of time, attention that is required to devote in order to nurture the skill. So the only solution I see is collaborate more and more. I, as a academic lawyer, my objective for my students and for the young professionals is always that I should collaborate more and more with the industry, have people so that they come and join us for the dialogue. We tell them what we are doing in the academics, in the academia world, and they share that how students can be prepared for the industry. So more and more such dialogues is something that is very much important, because that is how an idea gets popular, right? Let's start talking about it. Students can also write more and more about it, what your understanding is about mediation advocacy, or whatever you learn. Read, write, learn more and more about it. And at the same time, law schools, of course, we at Maharaja Agrasen, this is what our attempt is. And when we collaborated with FSRI for the first time, our objective was this, that we wanted to create this momentum in the country, and especially in the field of legal education, where we can very conveniently discuss the different nuances, the important nuances related to the ADR and the mediation practice. So yes, more and more such dialogues are very important at the law school. And yes, training of the faculty. I think maybe in coming years, we can see this mandate that ADR faculties should be trained, or at least some preference should be given to faculties who are trained in the ADR processes. And they should be the one. We have the concept of professor of practice. So I hope that concept is practiced a lot to teach, to inculcate mediation, advocacy and mediation practice. So I think that will benefit students the most. So yeah.
All right, Kriti. So that gives a fair understanding, I guess, onto that mediation advocacy is a different need of the hour at this point of time, and it's a different skill set that we need to nurture and that we need to develop and inculcate in ourselves, in our law students, in our law school curriculums. But that brings me, I guess, to the most important and my final question to both of you, Rukmani ma'am and you, as to what are the opportunities that lie ahead for us in mediation advocacy, in mediation, if I'm a professional, if I'm a young law student, how do I see this market? What are the things that I can do in this market? And is there a market, firstly? And that's my question for you.
I think Rukmani should go ahead, because she's handling CAMP, and CAMP is one of the finest organization when it comes to mediation in India. What are the opportunities? And what is the market?
Uh, with the coming of the act, there is so much more added in there to the field of mediation, especially for the young professionals who are entering the profession. First of all, if you understand mediation, there is a shift in your mindset, which helps you a long way in channelizing your energies as a professional. As I said, when you pass out, you cannot concentrate, irrespective of whether you are in litigation, whether you are a litigating counsel or you are an in-house counsel, wherever you are, you also sort of, you should pick up the necessary skills for advising a client as to how to go in for mediation. What is the importance of mediation? Especially for this is required the skills of negotiation. It's extremely important to be a good negotiator before you could advise your client as to how to negotiate. Like we have workshops at camp, we have workshops on negotiation, and we see some students coming in for that. So till you are well versed in your profession, in your professional life, wherever you start off as a lawyer, or don't think that because there is mediation, you finish your 5 years and you're going to become a mediator, even if you've done your 40 hours training. You do not, I mean, I'm not saying that you do not know what mediation is. Like as Kriti had put it very well, then it's very difficult, very different doing a role play as a role play for mediation and actually sitting in for a mediation. And for that, there is a little bit of experience and maturity required, which comes in, over a period of time. Like, somebody like Kriti, for example. Kriti has been in academics for, say, Kriti, how long now? 4 5 years since I've
Five,
known you?
five, 5 years. Yeah.
Oh, good, good. So 5 years. Now Kriti knows what the scenario about litigation, arbitration, mediation is. She would she's completed her 40 hours training. She's at
Mm.
the right position to, along with her academics, to do, to be a mediator, because she knows the finer nuances. She knows what to do, what not to do. I'd say the same thing about Anubhav also, having practiced for a little time, having been in camp for a little time. You need to understand a lot more about the psychology of the participants coming in,
Mm.
which is slightly difficult for young students coming out from the universities, from the law schools. I mean, they may have scored very well, they may have done very well, but your learnings as you go along. I mean, I've been mediating for 10 years, but I still feel that in the field of mediation, no, I still happen to be a litigating lawyer. But as far as mediation goes, I still feel that with every mediation, I
Mm.
still am learning so much as to how to become a better mediator.
Mm.
So I mean, that would be my reply to this question of Anubhav.
Uh, so, ma'am, if I'm hearing you right in there, and as I myself have been a first person uh, viewer, I guess, of the process from two sides of the table, seeing it from a law firm's
Yes.
perspective, firstly, and then coming in here, where I see that, yeah, there are certainly huge differences between the mindsets that we need to have for both of the processes, but which is equally important for both in there. If my client is asking me that I want to fight it out at court, I
Yeah,
might
of
give
course.
it a try convincing, but still may have to go to the court. But yeah, if my client wants resolution, I help them with resolution in here. And I guess with that, we also get a sort of an idea that this market is getting created. And I feel, since I have been looking into the international aspects of things, the positives for us is uh, maybe if we look at an example of the US today, which is such a mediation dominant economy where only 4% of the cases are going into their courts today for trial, and everything else is getting either mediated or conciliated or arbitrated outside the court. And maybe that's the place India as well is striving to be at, and that's the place hopefully we are at. And so the future holds all of these opportunities, but I also am aware that we are a bit over time. So if Kriti and Rukmani ma'am, both of you are fine with it, should we just take on a few questions that we have in the chat box?
Right.
Sure, sure, sure.
All right. So start out with, I have a question from Anjum. who wants to understand again the basic difference between arbitration, mediation, and conciliation.
Arbitration, mediation, and
Conciliation.
I think you should answer that, Anubhav.
So, Anjum, just to help you with that question, arbitration, we would say, is more like a private court setup wherein we have a third party giving in a judgment for us. There are submissions that lawyers give, there are claims that lawyers frame with their clients. But when you come into a mediation, this is more of an informal setup with a formal process in place, wherein a third party does not give a decision, but a third party helps facilitate a conversation between two parties. And when we talk of conciliation, conciliation as well was, I would say, a process which was pretty similar to mediation. But with the Mediation Act coming into the picture, the process of conciliation and the word conciliation is getting replaced by mediation everywhere. So in the coming years, when the Mediation Act fully comes into the picture, we'll only have mediation and arbitration as the outside court modes of resolution, along with negotiation always. And yeah, arbitration being like a private court setup, mediation being a place where if I'm a business owner, I can settle for myself. I don't have to get a third party to settle for me. I take my own decisions. A third party doesn't take my decisions. Just moving on to the next one, which is from Dinesh Prasad, where he wants to know when and how a mediation agreement becomes binding on parties.
When and how? For mediation, I would explain that scenario from 2 points of view. That is, one, what was being done before the Mediation Act came. Mediation Act, all the sections have not been notified. So we are still in the old scenario where, mediation, when, how and when, right?
Yes.
Anubhav? Now,
Yes.
how is that, you could be you could have been referred to a court mediation you by to a court mediation, in which case what happens is that the case that the dispute goes to a court appointed mediator, and if it is settled, the parties and the lawyers sign to this, and the agreement goes back to the court, and the court passes it as a decree, right? Now, there is also private mediation, like we have said at camp, we do private mediation. So we have references from court, but we have also cases which parties come on their own. In those cases, what happens is, the how is that when the parties do resolve their dispute, and they enter into an agreement, which is signed again by the parties and the lawyers. But here, they are not in court. So what happens is, this becomes a legally binding contract. And in case there is some, what do you call it, one of the parties violates any of these conditions, the other side can directly go in for the execution of such an agreement, or can go in for specific performance. The other choice we give in private mediation, especially at campus when they come in, is that you can get agreement to be a conciliator's award under the section 74. Am I right, Anubhav? Section 74 of the Arbitration and Conciliation Act, and get it certified as a conciliator's award. This is a scenario when there's no Mediation Act. Under the Mediation Act, the biggest advantage of the Mediation Act is that it says any mediation agreement is equal to a court decree. So I hope that answers your question. Kriti, would you like to add, Kriti or Anubhav, to that?
I think that's quite well-defined reply. That yes, it has, because now with the law, the only advantage is that it's a decree. It is binding.
Yes, exactly.
It was also before, because it's a agreement. It's a contract that both parties sign voluntarily. But now the status of it has been elevated to a court's
Elevate,
decree.
exactly.
So yeah,
Right.
it has force of a court's order. I think, Anubhav, we can take up the next question.
All right. So the next one is again from Dinesh, where he's checking in with us as to how does the process of mediation take place from the initial stage to the execution of the mediation agreement? I just want to check in with both of you all. If you all are comfortable, I could take this up.
Yeah.
Uh,
Yes.
so Dinesh, out of my experience being a case manager as well at CAMP, from the private mediation context, a mediation merely starts from an inquiry from a client or an advocate to a mediation institute like CAMP, wherein an advocate can reach out to us or a client can reach out to us to see that this is an issue we are involved in and we would like to check in if we can mediate this at your organization. Once we have that intimidation from one of the parties, it can either be that both parties come in together for a mediation, or it can be when one is ready, the other is not ready to come on board. Now, when the other is not ready to come on board, there might be mediation institutions who might offer support to get the other side on board. Not as a person supporting your claim, but as a person who's a neutral and as an institution who's trying to get both the parties on board. Once both the parties come on board and both the parties are ready to try out mediation, we host a process that's called convening. Now, convening is not a place where we are going deep into the mediation, but convening is a stage where a mediator tries to get an idea of what are the important aspects of this dispute, who are the stakeholders involved in this dispute, and does a mediator and how do the mediation advocates prepare for this mediation together. So how do we all prepare for this mediation together so that we can, I know that there are two disputing parties who might not be talking to each other as well, but this is the first step from where we start collaborating, be it in private sessions or in joint sessions, we try and frame it all together so that we are on the same page in terms of starting the mediation. Post which, we go on to signing an agreement to mediate. We go on to signing a confidentiality agreement so that the mediator, the advocates, and the clients ensure that whatever discussion takes place in the mediation here today or the days to come in does not go out anywhere unless there is an agreement signed. Once all of this is done, something that's very importantly done is a conflict check post this. Now, what's a conflict check? That's basically a process because we are all lawyers mostly. At this point of time, at least it's mostly lawyers who are also mediators. And lawyers being from the same circles might know other lawyers as well coming into the process. For example, I might be mediating a case for which Kriti might come in as a mediation advocate. And if she comes in there, I would have to make a declaration to the other side and even to her side that Kriti is somebody that I know professionally. And I can assure you that I'm going to be neutral for the process, but I know her. And that's a declaration I'm making. And if you want to change your mediator, please feel free to change your mediator in there if you feel there's a conflict. Once all of these documents are signed and the process is done, we go on to an opening session where the mediator would again help the parties understand what the mediation process is about and how he or she would want this process to flow through. Post which the parties are also given an opportunity now, be it in a joint session. A joint session is where we are all sitting together with both the parties. A private session is where we are sitting only with one of the parties or maybe a couple of the parties. In a joint session where we share out our concerns and where we try and hear out the other side as to what are they actually wanting to say. Because all of the time when we fight without a neutral in there, or even when we negotiate without a neutral in there, we might not have clarity onto our thoughts. We might only think, as Kriti said, of responding, but not of listening. But the neutral in there actually helps us in these listening capabilities. We have that opening session, post which an agenda for issues is set up. Then we go on to discuss, set our options down. And finally, we may or may not reach a settlement. When we do reach a settlement, the role of mediation advocates become even more prominent then, because it's not the mediator who drafts a settlement agreement. It is the mediation advocates who draft and help their clients with a mediation agreement. And once you set up an agreement, draw it down, then at present, we go into a process like if you want a court decree, as Rukmani ma'am said, we can go under section 74 or even section 89 of the CPC to a court of law and get a decree executed. But when the Mediation Act comes into the picture, it will all be under the Act, and an agreement as such can also be registered with a mediation institution. Uh, Post our mediation as well, when we are doing it in a private setting, we do constant follow-ups and checkups with the parties, because this is a process where we feel business wins. It's not just the parties who win. If you're a business or you're a relationship, the relationship wins. And we try and ensure that that win is therein for both the parties and they are not hesitant. I can any day revolt to a court decision and go and appeal against it. But if I'm deciding by myself, for myself, I don't think I'll be revolting to it. And that's the power of mediations. And Rukmani ma'am and Kriti, if you have anything to add on, speak. You're on mute.
As I had drawn a difference between court mediation and private mediation, Anubhav has brought out all the aspects of private mediation. In court mediation, what happens is, as I had mentioned, the cases get referred from court under Section 89 of the Civil Procedure Code. This could be, matrimonial. These could be civil cases. This could be commercial cases, cases of any nature. They could even be non-compoundable criminal offenses like check bouncing. So there, as I said, the parties come in for mediation, whether willing or not willing. I've had, because I'm a part of the court mediation at Bangalore, the parties who come in, that we only came in because the judge asked us to come. Did we have a choice? So that's the time when, as a mediator, you tell them that you do have a choice because it's a voluntary process. You please understand what the process is about. If you don't want to stay back, you're most welcome to go back to court and fight out your case. So I have seen say 80% people who say this, that I didn't want to come in, the court forced me to come. 80% of the people, when they hear what this process is about, they stay back. They stay back in the process and they mediate, and quite a few of them are able to settle. So in the court annex, it's that much, like we don't have convening, etc., because the cases are referred and it just is allotted to mediators. Then when you reach an agreement, you just have to go directly. I mean, the agreement goes to court and it becomes a court decree. Now, at camp, we've had court reference cases have been referred from court directly by the High Court or the Supreme Court. We've had cases where the cases are pending in court, and the counsels themselves tell the court that we want to go in for private mediation. And whatever agreement is reached over here, then it goes to court as a compromise decree under, I think, Section 23 of the Civil Procedure Code. So this is a fine difference between a mediation in a court program and a private mediation. I just wanted to highlight that, Anubhav.
Yes, ma'am. And certainly that gives in the perspective of how it happens for us at court. And that also just brings me to a last point, and I guess we are a bit over time to close this down. And I heard you once talking about even when parties have not settled in a mediation, have gone back, taken 6 months, and then called you back to say that, oh, we've settled in this
Yes.
matter. So that's
Yeah,
where the
exactly.
process. Yeah.
So what happens is, a lot of, what you should, our founder Lela always says that, you can't force mediation down the throats of parties. There should be a right time for parties to mediate. And that right time sometimes is when they experienced court. They may come in even to, like Anubhav was saying, that they come in, ask about mediation, then they know we'd rather go to court. It has happened in a few cases. So when they come back, but at that point of time, they know about mediation. They go to court, and after about 3 to 4 months, they come back saying, because they know about mediation, they say we rather do it here because it's so much faster, and we are sure we'll be able to resolve it. And we don't want to be in court for years together, spend our time and spoil our especially if it's a business relation, spoil our relationship.
Thank you for that, ma'am. And with that, I'll hand it over to Khushi and Preeti. I'm just checking in case you have anything to add, or we can hand it over to Khushi for closing of this.
I I think Rukmani and both of you have covered it largely. So I think we can give it to Kushi to wrap up.
All right. Thank you. Thank you for the wonderful
I
panel
think
discussion. I personally enjoyed a lot
we've
in this.
exceeded the time a bit too much.
Yeah.
Yeah. So thank you, esteemed panelists. I really would like to thank Rukmani Menon ma'am and Ms. Kriti Johri ma'am for always and always encouraging us to go for a mediation. I personally enjoyed this panel discussion a lot. Much. And yeah, thank you participants for joining us on the Sunday morning. So yeah, it's a lunchtime, so we can just close it. Thank you.
Thank you all. Thank you. Thank you so much.
It was beautifully
Bye-bye.
moderated by Anubhav sir. The process he described in a very good manner. So thank you, sir, for being here.
You.
Thank you. We had a very good session. Thank you all, co-cap panelists. Thank you, Kriti. Thank you, Anubhav. And thank you so much, Khushi.
Thank
Bye-bye.
you all.
Enjoy the rest of
And
your Sunday.
Bye.
yes, thank you. Thank
Akshay, can we stop the recording? Thank you.